Hello everyone. Today we are going to see about the judgment for the month of October 2023. Let's start with the first case. Supreme Court verdict on eradicating manual scavenging in India. Case name Balram Singh vs Union of India and others. Writ petition Civil 324/2020. Union is directed to ensure that the manual sewer cleaning is completely eradicated in a phased manner. If outsourced, it does not require individuals to enter its sewers. Full rehabilitation to the sewers workers. There was skill training measure. Compensation increased from 10 lakhs to 30 lakhs. If sewer victim suffering disability, then depending upon the disability, compensation to be awarded minimum 10 lakhs, permanent 20 lakhs. Also set up scholarship for education for dependents of the victim sewer who has died or suffered disabilities. In order to practice the monetary liability, cancellation of the contract if employed through contract shall be ensured by Union, State and UT. Union, State and UT to set up state level, district level committees to ensure its adherence. Next case, Supreme Court verdict on legal recognition for same-sex and queer marriage. Writ petition civil number 1011 of 2022. Case name Supriyo and Supriya Chakraborty and another versus Union of India. 17/10/2023. It was declined to allow marriage for non-heterosexual couples since there is no fundamental right to marry in the Constitution of India. Also declined the right to adoption to queer couples. Next, Judgment 3, irrevocable breakdown of marriage. Supreme Court verdict, irrevocable breakdown of marriage is not a straight jacket formula on divorce under Article 142 of Constitution. Case name Dr. Nirmala Singh Panishwar vs. Mr. Paramjit Kaur Paneshwar and Ajitir Kaur Paneshwar. Civil Appeal number 2045 of 2011. Divorce plea filed by 89-year-old man from his 82-year-old wife citing irrevocable breakdown of marriage. Although respondent wife has maintained this sacred relationship and also cared for the 3 children in spite of husband applied being hostile towards them. The wife still want to be in that relationship and care for his husband at this stage and doesn't want to die being tagged as divorcee. Keeping the sentiment of the wife in mind, Supreme Court dismissed the case of husband appellate. On the fact of the case, court took the considered view that in contemporary society it may not constitute stigma, but here we are connected with the respondent own sentiment. Under the circumstance, considering respecting the sentiment of the respondent wife, the court is of the opinion that exercising the discretion in favor of appellate under Article 142 by dissolving the marriage between parties on the ground that the marriage has irrevocably broke down would not be doing complete justice to the party, would rather be doing injustice to the respondent. Next judgment. Dismissal of petition by Supreme Court as expertise and merit are the criteria for senior advocate designation. Case name Matthews J. Nedumbara vs. Union of India. Writ petition C number 320 of 2023. Petition dismissed because the court said the classification of advocates under section 16 of the Act is tangible difference established by the advocate with their practice over the decades, and hence the court has devised a discernible and transparent mechanism to adjudicate seniority of advocates in professions. The court stated that expertise and merits are the criteria. The court said that designation of senior advocates comes with a restriction on many acts which they could otherwise perform as advocate. That is why a lot of advocates prefer to remain as advocate or record or advocates in the high court and district court. As a designation as senior advocate carries many inhibition in the role that they can perform. That is, they have to appear with an instructing counsel, not to draft file pleading, not to deal with litigate, etc. Therefore court said that a designation as a senior advocate is a recognition of merit by the court. Court also added that the seniority of advocate is premised on standardized metric of merit aimed at forwarding the standards of profession. Thus, classification of advocates and the mechanism grant seniority advocate not based on any arbitrary, artificial, or evasive grounds. Next, judgment 5. Supreme Court verdict involving public declaration of marriage held privately. Case name Ilavarsan vs. State. Criminal appeal numbers of 2023 arising out of SLP criminal numbers 6534 of 2023. Basis: the court considered a challenge to a judgment of Madras High Court which dealt with Section 7A of Hindu Marriage Act, which merely required the intended spouses to declare to each other their willingness to take each other as spouses and symbolically garlanding each other to get married. High Court was of the opinion that such marriages involved in a public declaration. Supreme Court negated the finding of High Court on the said aspect and held that High Court superimposed a condition High Court superimposed a condition of public declaration which was absent in Section 7A and also violative of Article 21 of the Constitution. However, the court upheld the observation of High Court. Advocates should not, and in their capacity as advocate, undertake or volunteer to solemnize marriages. Next, judgment. Supreme Court verdict in 26 weeks pregnancy case. X vs. Union of India and another miscellaneous application number 2157 of 2023, writ petition civil number 1137 of 2023. Basis: married couple filed a writ petition for termination of pregnancy on the ground of her mental condition do not permit her to raise another child and financial reason. Two reasons. And the court said that the length of pregnancy has crossed 24 weeks. The statutory limit of medical termination of pregnancy. Also, since there are no substantial fetus abnormality diagnosed by medical board, then the court did not accede to the prayer of the petition for medical termination of pregnancy. Next, judgment 7. Res ipsa loquitur. For a case of res ipsa loquitur, the claimant must show the defendant was in control of the situation which caused the injury. The injury was more likely than not to have been caused by negligence. If the claimant can show these two things, the burden of proofs moves to the defendant, who has to prove that he or she was not negligent. Strong incriminating evidence required for application of res ipsa loquitur. Case name Kalyani Rajan vs. Indra Prasada, Apollo Hospital and other. Supreme Court of India, appeal number 10347 of 2020. Basis: complainant or appellant is the wife of deceased patient who was 37 years old, died on 6/11/1998 in Indira Pradesh Apollo Hospital while undergoing follow-up care and treatment after a major neurosurgery in the care of respondent. After performing pre-operative medical examination, respondent conducted the operation of the deceased. The deceased was thereafter shifted to a private room. Thereafter, doctor visiting the deceased were informed about pain in the neck region, which seemed to have transferred lower where pain used to occur prior to operation. Next, The deceased suffered a heart attack and declared brain death on 13/10/1998. The grievance of appellant is that the deceased was not attended to by any doctor from neurosurgery team who had operated him after he was shifted into the private room till 11 p.m. After such major surgery, instead of shifting to a private room, the deceased should have been shifted to the intensive care unit. The verdict court said that there was no mistake in diagnosis or negligent diagnosis by respondent in the absence of the patient having any history of diabetes, hypertension or cardiac problem. It is difficult to foresee a possible cardiac problem only because patient had suffered pain in the neck region. Next case, Judgement 8, land sale by fraud. Supreme Court extends interim protection against arrest. Justice A.S. Bopana and Justice P.S. Narasimha. Supreme Court extends the interim protection against arrest in the case of land sale by fraud. Case name Suryagan vs. State of Rajasthan 2023 SSC Online SC 1325. Basis: the appellant fraudulently got mutation done in his favor for the land belonging to the complainant and hold the land by cheating and malafide intention. To anticipatory bail was rejected by Session Court and High Court, respectively, bending the investigation. Since the charge is serious, the state opposed interim production and may require custodial interrogation. Verdict: the court said that there was no specific complaint of non-cooperation in the investigation. The court reiterated the requirement for the appellant to diligently participate in the investigation and further process ordered continuation of the interim production till the contemplation of the process. Next, Judgement 9. Supreme Court COVID-19 limitation period suspension included outer limit of period of condoned delay. Adityan case name Adityan Kaitan vs. IL and FS Financial Service Limited, civil appeal number 6411-6418 of 2023, arising out of SLP civil numbers 47892 to 4796 of 2021. Basis: on 30/8/2019, IL and Financial Service Limited filed a suit of recovery of money and other constitutional relief from before Calcutta High Court against 9 defendants who were appellant in instant matter. The summons were served on the defendant on 7/2/2020 and the 30-day period of filing written statement expired on 8/3/2020, followed by expiry of 90 days period for contention of delay on 6/6/2020. On 21/2021, the appellant filed a application praying for acceptance of written statement by extending the time, stating delay due to lockdown after COVID-19 pandemic 23/3/2020 when their office was completely closed. Since the order of this court under Article 142 of the Constitution of India extend only the period of limitation and not the period of up to which delay can be continued, the application for taking on record the written statement cannot be entertained. Verdict: the summons were served on 7/2/2020, 30 days period expired on 8/3/2020, outer limit 120 days expired 6/6/2020. The application of taking on record the written statement extension of time was filed on 21/2021. Applying the order of the 8/3/2021, order made thereafter excluding the time stipulated, the applications filed by applicant 19/1/2021 are well within time. For the reasons stated above, appeals are allowed and written statement 2021 direct to be taken on record. Judgement 10. NCLAT members defeat status quo order by Supreme Court, contempt notice issued. Orbit Electrical Private Limited vs. Deepak Kishan Chahabaria Company Appeal 80 number 64 of 2020. On October 13, Top Code had passed an order directing the NCLAT to defer pronouncement of its order in the case regarding the disclosure of the result of annual general meeting of Finolux cables till the time results of the AGM were submitted in the form of the reported by the scrutinizer. The Supreme Court went on set aside order of NCLAT, which was passed against its direction of status quo, and transferred the same to bench led by NCLAT chairperson. Next, the notably after the Supreme Court had passed on order of status quo, it was later informed on the same day that the NCLAT had proceeded to deliver the judgment. Hearing this, court had directed its chairperson Justice Ashok Bhushan to conduct an inquiry. The inquiry report was placed before the bench today. It was two NCLAT members told the chairperson that they were not aware of the Supreme Court order. Verdict: the Supreme Court issued competent notice to two members of the National Company Law Appellate Tribunal, New Delhi, defying its order of the status quo, pronouncing its judgment in case pertaining to the Finolux cable. Judicial member Justice Rakesh Kumar and technical member Dr. Alok Srinivasa have been directed to show cause and be personally present before court on October 30, 2030. Thanks for watching this video. All the best for your examination.